All right. Well, I was asked to give a basic explanation of Marbury versus Madison, one of the definitive Supreme Court cases early in our country's history. And so I figured I could give a quick rundown of this particular court case. Now, bear in mind, I taught high school government for a number of years. I do not have a PhD in this. And so if you want a definite expert analysis of this, I'm not your guy, but I could at least tell you what I do know about it and what I taught about it when I was teaching American government and political science to 12th graders for all those years. And so Marbury versus Madison explained. What I'll do first is I'll give just a quick overview of what was going on, and then we'll get to the issues of this. Okay, so pretty much what happened is the second president of the United States, President John Adams, his term expired in 1801. And so before his term expired, Congress passed a bill that gave the president a chance to appoint 42 justices of the peace in the District of Columbia, or D.C., Washington, D.C. And so the idea here was that the Judicial Act of 1789 gave Congress the ability to create lower courts and create judgeships or judge positions. And so Adams lost the election to Thomas Jefferson, and one of his plans was to appoint a lot of judges that shared his politics rather than the politics of Thomas Jefferson. And so specifically, there were 42 justices of the peace that were supposed to be selected for the District of Columbia. And so the Secretary of State at the time was John Marshall. He delivered all but 4 of those commissions to the new officers by the day Thomas Jefferson was inaugurated as president. And so what that means is not all 42 were delivered. 38 were delivered. There were 4 commissions that they just ran out of time and didn't deliver. So 4 people had not received their position as a judge yet. Now, technically, what Jefferson, as the president, was supposed to do was have his Secretary of State deliver those final 4 commissions. But one of his very first acts as president was to not do that. He stopped the delivery of the remaining commissions. So now these 4 guys were not going to receive their job as a judge. Now, one of those 4 guys, his name was William Marbury. And that's why this court case is called Marbury versus Madison. Specifically because William Marbury wanted that position as judge. He was guaranteed it, but the current president, Thomas Jefferson, was not giving him the position. Now, Thomas Jefferson's Secretary of State, James Madison, was supposed to deliver those commissions, but Jefferson said, Madison, you will not do this. And so because of that, that's why Marbury sues, and it's called Marbury versus Madison. And the reason Marbury was able to sue was because of a specific provision that was part of the Judiciary Act of 1789. And I'll explain what all this means as I go on. I just wanted to give you the overview of what was going on here. Now, one thing that John Adams did before his presidency ended is he appointed his own Secretary of State. He appointed him as the new Chief Justice of the Supreme Court. So John Marshall now becomes the Chief Justice of the Supreme Court. So by the time Jefferson is president, Marshall is now the Chief Justice of the Supreme Court. And so pretty much this case goes before Marshall, and Marshall announces that Marbury has been cheated. His rights have been violated. He should have received his commission. But ultimately what Marshall said was that Marbury didn't have the right, though, to take this case directly to the Supreme Court. There was that provision of the Judiciary Act of 1789 that said Marbury could go straight to the Supreme Court. But what Marshall's going to say is that provision gives the court more power than the Constitution actually gives the court. And so what he did is he struck down the Judiciary Act, Judge Marshall did, as unconstitutional. Now, the technical term for this is judicial review. That is where the Supreme Court can strike down what Congress or the president does, could strike it down as unconstitutional. And in that case, it would make the act null and void. And so the reason why this court case is so important is because the Chief Justice was able to strike down a law as unconstitutional and thereby establish that it really does have this power. Okay? Now that's the summary. this might not all make sense yet. So hopefully now as I tell the story of this all, maybe it'll make a little more sense. So as I go to the next slide, I ask the question, what is the drama all about? Well, it starts with a contentious presidential election. As you know, George Washington was the first president starting in 1789, and he served 2 terms. And under George Washington's presidency, you had the development of political parties, really that developed around different personalities. And so you had the Federalist Party, which centered around guys like Alexander Hamilton and John Adams. And then you had the Democratic Republicans, which centered around Thomas Jefferson. Now, after 2 terms, George Washington said, I'm not going to run again. And so John Adams ran and Thomas Jefferson ran against him. And it was a very close election, but John Adams barely won. And so for the next 4 years, Thomas Jefferson's doing whatever he can to obstruct John Adams from running the country. Now, when John Adams won, he was the Federalist. Congress was mainly Federalist as well. Okay, both the Senate and the House had a majority of Federalists in it. And so, if just from that standpoint, the Federalist Party was ruling our country. Well, 4 years later, Thomas Jefferson runs against John Adams again, and this time Thomas Jefferson wins. Again, it was close, but he won. And his party, the Democratic Republicans, as they were called back then, also won a majority of the seats in Congress. Now, back then, from the time of a presidential election until the time where the new president comes in, it was a period of about 6 months. So John Adams lost, his Federalist buddies in Congress lost, but they had 6 months to get things done before Jefferson and his guys come in and take over. So in that 6 months, that's what they did. They created a bunch of lower courts, including those 42 seats in Washington, D.C. And then they figured they have 6 months to create those courts and then appoint Federalists as judges. Because the thing is, judges aren't elected. So even though Adams lost the presidency and the Federalists lost the Congress, they could they could hold on to the judicial branch. If he could appoint a bunch of Federalist judges to all these new seats they created, then you would have a majority of Federalist judges. And so that was John Adams' plan, to keep the Federalist Party at least having a say in the government. And so in that 6 months, they create these positions, they deliver the commissions, all except 4, okay, which I already mentioned. So by the time Adams' term ended and Jefferson's began, 38 of the 42 justices of the peace in D.C. were appointed. And as I said, Jefferson then refused to appoint the remaining 4. He said, this is dirty. I don't like what John Adams and the Federalists did, so I'm not going to follow it. Now, even if it was dirty, it was legal. Okay, John Adams and the Federalists did what was lawful by the Constitution. Congress passed a law, they created courts, and then they followed the procedure to appoint positions. So even though Jefferson didn't like it, he had no right to not deliver these 4 remaining commissions. But Jefferson was stubborn. And so he told his Secretary of State, James Madison, you are not to do this. You will not deliver these final 4 commissions. Now, I mentioned earlier, William Marbury was supposed to receive one of those commissions, and when he didn't, he was very upset, and so he wanted to see if there was a way he could challenge this. Now, I'm going to go back a few years to 1789, when George Washington first became president. One of the very first things the very first Congress passed was the Judicial Act of 1789. And the Judicial Act of 1789 gave the Supreme Court the power to issue what's called a writ of mandamus. I'm not sure if that's how you pronounce it. It could be mandamus, whatever. But it was the power to issue a writ of mandamus. Now, what is that? Well, it's a court order that forces an officer of the government to do what he's supposed to do. So, Jefferson is telling James Madison, you are not to deliver these 4 commissions. Yet, by law, he's supposed to deliver those 4 commissions. So if the Supreme Court issued a writ of mandamus to James Madison, it would require him to deliver those 4 commissions that President Jefferson was telling him he could not deliver. And so Marbury figured, you know what? I'm being cheated out of this position as judge. I want it. And this law passed in 1789 gives the Supreme Court the ability to make Madison give me my commission as a judge. And so on that basis, he sues, and it goes straight to the Supreme Court. Now, Marshall is between a rock and a hard place on this, and here's what I mean. President Jefferson said, I don't care what John Marshall says. If the Supreme Court rules against me, I'm going to ignore them. We are not delivering these 4 commissions. Now, I don't know if you know how dangerous that was, but our country was just getting off the ground. And if the first time the third branch, the judicial branch, challenges the second branch, the executive branch, the presidency, and tells the president he's wrong, and yet the president then says, I don't care, you can't force me to do it, I could tell you our democracy would not have made it this far. It would have crumbled at the beginning. I mean, I know a lot of people like Thomas Jefferson, but this was just plain out wrong what he was doing. He said, I don't care what the Supreme Court says. And so Marshall, as the Chief Justice of the Supreme Court's like, okay, what do I do? Because Jefferson's clearly wrong. But if I tell him he's wrong and command him with judicial review to deliver these 4 commissions, and then he just tells me to go pound sand, then henceforth the Supreme Court has no power. The first president to ever be challenged would have resisted it. All other presidents will resist it. Really what this comes down to is the first time a government branch is going to use its most important power. If on that first time it gets ignored, then that power is not going to exist henceforth. So Marshall has to figure out how to use this power of the Supreme Court, but use it in a way that is successful and that can be used henceforth in the future. So Marshall's actually a genius here. He asks 3 questions. He asks first, does Marbury have a right to the appointment? And the answer was yes, because Congress passed the law to create those judge seats, and they followed the detailed process to make these commissions and to deliver them. And so Marbury, by the power of the law, yes, he deserves that judge position. Thomas Jefferson's wrong. The second question is, do the laws of the country give Marbury a way to have things set right? Well, yes, it does. If the President of the United States refuses to, I guess you could say, execute the laws of Congress, which is one of the President's chief jobs, then there has to be legal remedies that Marbury could take that would force the President to do what he's supposed to do. Okay, so yes on questions 1 and 2. And so where you would think this would go is he's going to then tell Jefferson he better deliver these commissions. But since Marshall knows Jefferson won't do it, he's going to be kind of slick here. There's a third question. The third question is this. Does asking the Supreme Court for a writ of mandamus, is that the legal remedy? See, what he determined is there is a legal remedy, but is this the one? Like, is Marbury following the right process? And to that, John Marshall says no. Because when you read the Constitution of the United States, it does not grant the Supreme Court the right to issue a writ of mandamus. It does not give the Supreme Court the right to enforce a government official to do their job. That's not in the Constitution. Instead, what's in the Constitution when it comes to the Supreme Court is the Supreme Court has 2 kinds of jurisdictions. One is called original jurisdiction. The second is called appellate jurisdiction. Original jurisdiction, these are cases that automatically go to the Supreme Court. They don't start at lower courts. So if it has to deal with the president or Congress or like a high government official or a conflict between 2 states, that goes straight to the Supreme Court. That's original jurisdiction. All other cases would go to the court through appellate jurisdiction, meaning they start in lower courts, but the lower courts can't seem to fully solve it, so it could be appealed up to the Supreme Court, and on that they could then receive the case through appellate jurisdiction. Well, what Marshall understood was that the Supreme Court could potentially take Marbury's case, but it's an appellate jurisdiction case, not an original jurisdiction case. And what the Judiciary Act of 1789 did is it skipped the process and made it to where Marbury could go straight to the Supreme Court as original jurisdiction rather than first taking it down to the lower courts. And what Marshall said is the Constitution does not allow that. So what he did is he struck down the Judiciary Act of 1789. He said, Marbury, you deserve the position. Marbury, there is a legal remedy you could take, but Mr. Marbury, taking it straight to the Supreme Court because of what's in the Judiciary Act of 1789, that was wrong. So I'm going to strike down the Judiciary Act of 1789. You need to then take this to the lower courts and have them force Jefferson to do this. And if he won't listen, then you could appeal it back up to the Supreme Court and we will deal with it then. Okay? And so that's pretty much what this was. And by doing it this way, it established judicial review. Okay, this was the first time, controversially speaking, that this power was going to be used. And so Marshall needed to use it on something that Jefferson couldn't stop. And so he did. Jefferson doesn't care about the Judiciary Act of 1789, so by John Marshall and the Supreme Court striking that law down, he henceforth cemented judicial review in our legal system. And now the future courts could use the same power. And in fact, Marshall will use this power many times in his long career as Chief Justice. And then, of course, the Supreme Court's been using it ever since. And, you know, the idea would be by the time Marbury would work this through the lower courts back up to the higher court, chances are Jefferson wouldn't be there anymore. And so what would happen is Marshall would get to avoid the whole threat that Jefferson was making here. So it was a stroke of genius because it used the power in a way that wasn't challenged, but at the same time it did duck the issue, and Jefferson got away with really being a punk. I mean, that's just the best way to put it. Jefferson was wrong, but this was a situation where Jefferson got what he wanted, and yet John Marshall got what he wanted by establishing judicial review. Now, the reason why judicial review is so controversial is because it's not directly stated in the Constitution. The Constitution implies that the Supreme Court could strike down the actions of the other two branches or states or whatever. It implies it, but it doesn't say it. Now, we know that this was the intent of the framers because if you ever get the chance, you should read the Federalist Papers. When the Constitution was going through the ratification process, two big states were required. If you were going to get the new country to support the Constitution, you needed Virginia and you needed New York on board because they were the two biggest states. Well, in New York, you had Alexander Hamilton, James Madison, and John Jay started writing newspaper articles under fake names where they were arguing in favor of the Constitution. Now, keep in mind, James Madison is the chief author of the Constitution, and these other two also had a hand in creating the Constitution. So they would know what the Constitution means, right? So as they're trying to convince New Yorkers to support the Constitution, they're doing it through these newspaper articles. Well, later, these articles were all compiled into now a single volume called the Federalist Papers. And in Federalist Paper number 78, Alexander Hamilton directly says that the Supreme Court should always go with the Constitution if the legislative branch, aka the Congress, makes a law in opposition to it. So what he's saying is that the Supreme Court should strike down a congressional law if it violates the Constitution. That is judicial review. So was it intended by the framers? Yes. But since it wasn't directly stated, there needed to be a good test case where it could be used and in a way where it doesn't get shot down, and then it could be used henceforth, and that's exactly what John Marshall pulled off. And the long-term significance of this is it expanded the power of the Supreme Court. It's been using this power ever since, and the reason why this creates current problems is because nobody questions this power anymore. And so now you got all these liberal leftist progressives out there who they want to push their agenda not through the democratic process. See, the democratic process says elect your people to Congress, have Congress pass laws, elect your person as president. The president then signs those laws, those bills into law, right? That's how you change things. Well, if you notice, the progressives, they can't really get any laws passed. So what they've been doing since the 1960s is they've been going to the Supreme Court and they've been bypassing the legislative and executive branch. And so then they get these 9 judges who are not elected, they're not accountable to us, and they get these guys to keep striking things down as unconstitutional and inventing new rights and new laws here and there. And what happens is pretty much a lot of the rights that are established right now actually did not come through the democratic process, but has come through judicial review, which really ends up being almost like a dictatorship of 9 judges, because there's no way to counter their judicial review. So that's where there's problems with this, and that's why when guys like Brett Kavanaugh and Amy Coney Barrett were nominated as potential judges for the Supreme Court, the left just went bonkers and haywire because they know that these particular judges are not going to abuse the power of the Supreme Court. Whereas liberal judges, they don't care about Congress or the president. They believe their position as judge is to use judicial review to change the country into what they want it to be. That's not democracy. So people like Kavanaugh and Gorsuch and Amy Coney Barrett, they're the type who say it's not the court's job to make laws. We are simply here to strike down things that are clearly unconstitutional. So that's the right way to use judicial review. But again, the left likes to use it the wrong way. So those are the current issues that go with it. But everything I explained in this 20-something minutes was meant to show you what Marbury versus Madison was all about, and really why judicial review is as important as it is. So I hope this helps people who may have otherwise not understood this. Thanks for listening.